Right, thank you. Afternoon, members. Can I just remind everyone present that this meeting will be recorded and that the recording will subsequently be available for public listening. Can I ask for the apologies, please?
Chairman, of apologies from Councillor Brodie, and Councillor Maitland is substituting for him. There's 7 members present this afternoon.
Thank you. And can I ask that any members have any declarations of interest? None. Thank you. This is the first meeting of the ad hoc subcommittee since our last recommendations were agreed at full council in November 2013. There were a number of outstanding issues that were held in abeyance until now, and most of these are covered in the report before you today. The issues that we are still working on are the scheme of delegation to officers and governance and reporting arrangements for council-led forums and groups. Derek Crichton's here to answer members' questions, and the main issues to be covered today are scheme of appointments to role and outside bodies, amendments to standing orders, and consider again the outstanding request for Councillor Scobie. So, any members, any questions? Councillor Carruthers.
Chairman, just a point of clarity to start off with. I've got 2 or 3 more just questions of interest and inquiry, nothing really to dig into. But in scrutiny performance last week, it was raised there in regards to process, in regards to complaints process for councillors themselves in regards to the council. And it said the best place to look at that was actually this committee here. So it's how do we actually, if we could take governance advice in regards to how do we go about raising that and getting it onto the agenda, please?
Okay, thank you. Derek?
It's perfectly acceptable for another committee to ask another committee to undertake a piece of work, so it just be factored into the business agenda at whatever the next meeting is of the ad hoc sub. It's not been scheduled yet, but we could look at the next meeting. Just need to be some clarification on what exactly the request was when I see the minutes of the meeting. Councillor Carruthers.
Thanks, Claire. Councillor Carruthers?
It was myself that raised it, Chair, so it was to be absolutely clear, it's in regards to there's no process in place for members of the council to complain, to make a formal complaint in any way or complain. There's a process in which we can inquire and raise issues, but we can't actually complain. And it was in regards to that process. It was about getting a process in place, what possible designs could be put into place with the committee structure, so on and so forth. So that's what we're looking for to get that on the agenda, please.
Okay, thank you. The governance officer has indicated that sight of those minutes and clarity around the expectations forthcoming from the scrutiny committee discussions will be examined and the business for council taken forward on that basis. So we may see it coming here. That will be a decision to be taken by governance once those minutes have been examined. Councillor Geddes?
Well, I would suggest, sir, if we're not careful, because I mean this issue was raised at the last meeting of Audit and Risk Management as well, and I don't think it's appropriate or the best way to utilise resources, as it were, if you'll forgive the colloquialism, to hawk it around the various committees. At the end of the day, it's a hugely and a fundamentally important issue. And I would like to think, in fact, that we can sort of fast-track it to either the full council itself or alternatively to the senior corporate committee, which is Policy and Resources Committee. This is something which impacts on, all 47 members and all the legitimate areas of activity. And I would think on that basis that, as I say, rather than sort of it being raised, at audit and risk, being raised obviously as it was at scrutiny and in various other forums, that, a grip should be taken of it, and we should get this parachuted into, getting the most expeditious process arrived at to allow us to come to the decisions that manifestly need to be arrived at in relation to these issues. And let me say that that was my view, certainly in relation to Councillor Bell and Scobie having raised it at audit and risk, as you'll probably recollect.
Thank you. Members of this committee aren't necessarily also members of Scrutiny Committee or other committees where this topic may have been discussed. This topic is not an item of business for today, and I wouldn't propose any more time being spent on it than has already been done. We've had an explanation from governance as to how the business will be taken forward, and for those members who are not members of those committees where the discussion has previously taken place, they will be alerted also if the governance officers see fit to take that piece of business forward. Councillor Hislop.
Chair, could we ask if there is an early answer to which committee it's going to, that all group leaders at least are notified so that we know where it's going, because we don't want to lose sight of this?
Thank you. Yes, the governance officer has a note of that. Councillor Carruthers.
Thanks, Chair. No, I mean, it was quite a relaxed conversation at both committees. I was in the public gallery at the Audit and Risk, and I was actually on the committee at Scrutiny Performance. But what was made very clear there was that if we don't get it done in a timious fashion, we'll raise it at full council through a motion.
Moving on to the business in hand. Any members, any questions regarding the papers before you today and those recommendations? Councillor Geddes.
Well, can I say first of all, or can I ask first of all, so that we take them in sequence, if that's at all possible, and if that is acceptable to you, leader, you know, Chair, the first issue 2.1 is the reviewing the draft scheme of appointments to roles and outside bodies. I think there has, in my opinion, sir, to be a distinction arrived at, as soon as possible, I may say, between the respective roles of decision maker and advisor, observer on the part of elected members on outside bodies. Because too often in the past, elected members, you know, are levered into a situation where they serve as directors, or can serve as directors or trustees in external bodies, and as a consequence, Chair, they become subject to the full rigours, as it were, of company law and other forms of law. And my own assessment, from bitter perhaps, shall I say, on occasions, personal experience, is that we're put in there, and at the end of the day, we're allowed, as it were, to sink or swim. And I'm sure that I'm not the only member of the 47 who would take that view. And my opinion is that we should be moving as quickly as possible, as it were, to a scheme, as it were, of advisors, observers. And if you go further on in the papers, sir, there's various issues made with which I certainly, on this point, would take issue. For instance, if you go to Appendix 1, Chair, and you see the introduction, paragraph 1.1, and it talks about councillors gaining additional knowledge and expertise through membership of these organisations, which they can then put to use in discussing a range of issues within the council chamber. Well, that to me, sir, is just a wee bit bias, because the blunt fact of the matter that in most instances you've got to declare an interest, as it were, and leave the chamber when it's an issue which comes up from an organisation, external organisation, of which you're a trustee and a director. So my exhortation, you know, to in relation to that would be, come on, get real. That and it's not anything like that at all. As I say, and there's a whole raft of other issues which I personally feel we should, in fact, be taking up to give much greater degree of support and reassurance to those that we put in to the position of trustees and directors in such organisations. And with your leave, once I've heard colleagues, I would like to come back to that, sir.
Thank you. Councillor Smith.
Can I just get clarification on two or three things? That effectively, if you look at the list of outside bodies, those that are in green are effectively internal groups. So for an internal group, if you're a member of that group and an issue in relation to that group comes up at a service committee, you wouldn't have to declare an interest. Is that the case? Because it's effectively it'd be like me sitting on housing committee, but then the matter being referred to EEI committee, and I wouldn't declare an interest saying I was on housing committee. Is that the same with these internal organisations? You don't need to declare an interest because actually it's an internal organisation. That's the first question. The second point is around the difference between decision maker and advisor or observer. It says in 3.6.2, it's proposed that an alternative defined role be offered as an option for members. Can I just clarify what we mean by offered as an option? I mean, presumably we'll take each individual outside body and we will define in the scheme of delegations which one. It's not as if we're going to say to a member, you're a member of COSLA, but you can decide whether you're going to be an observer or a decision maker, although when it comes to COSLA, you might as well be an observer these days, to be honest, given the influence we have. But you know, you won't have to define that individually. That'll simply be defined in the scheme of delegation, will it?
On the first count, you could declare an interest. However, you would not be required to vacate the discussion. On the second one, if I can just ask Mr. Crichton.
Thank you, Chairman. Just to confirm, the intention today is firstly to enable members to consider 361, 362, and therefore, if you think that's the way forward, the next stage of that process would be for the scheme itself to then set out quite clearly what the expectation of the member role is, e.g. the example given in COSLA, quite clearly we would anticipate it would be decision maker, and that would be set out in the scheme. Thank you, Chairman.
Thank you. Councillor Carruthers, or is it the same topic, Alistair? Thank you, Councillor Carruthers.
Chairman, I'm happy to give way because mine. I've got 2 or 3 questions on different parts. Just to keep it flowing, if you want.
Thanks very much, sir. And we're still on the issue of outside bodies, as far as I understand. And one of the issues, paragraph 3.2 on page 11, sir, talks about membership of outside bodies, and I would want this clarified and queried. Once appointed to an outside body, councillors are then bound by the rules of conduct of these organisations, and the responsibility for any actions taken by them as a member of such an organisation will be to the organisation in question. Now, I have no problems whatsoever with that, Chair. It's the next bit I have problems with. They must also continue to observe the rules of the Council's Code of Conduct while carrying out the duties of the outside body. As far as I'm concerned, I'd be doubtful about the legality, Chair, of that. You can't have it both ways. If you're a member of an outside body and you're responsible to that outside body, you're surely bound by the rules of the outside body. And, if you're endeavouring, as it were, to double up, as it were, and say that, notwithstanding, you will still be required to observe the Council's Code of Conduct, that seems to me something akin or not dissimilar to such as a double whammy, again, if I can use a colloquialism. So, why should an elected member be put in such a situation? They have an allegiance to the outside body. At the end of the day, they are obliged, as it were, to act and to accept the responsibility in relation to that. But on the top of that, they're still subject to the Council's Code of Conduct, even though they're not strictly speaking a councillor and carrying out the functions of an outside body. Is the way I read that. That's another issue I would want flagged up, for clarification on, sir, as part of the process.
Thank you. Jekyll and Hyde comes to mind, actually. Councillor Maitland.
It was really about the sort of issue of being an observer and just thinking about the practicalities of it and the nature of members. I understand that if we decide in principle today, then there will be a scheme of information coming forward, Chairman. Is that right? So it's an in-principle decision that we want to think about the split. Okay, well, if that's the case, then I don't have any difficulties with the idea, but I do think that it will be incumbent on us in the scheme of delegation and explanation and support to say to members that they probably have to keep advising the body of the nature of their presence there, because people forget and things change, and it's very easy to slide from advisor into suggester and shaper. Very, very easy. And I would just say that I'm not completely clear as to how that can be constantly made clear it's to stay like that division.
Yeah, thank you. I would also add that on page 10, 2.5, 2.6, 2.6 in particular, I was intrigued to read the outside body's constitution and officer scrutiny questionnaire forms can be viewed on request. I didn't know there was such an animal. And a broader understanding and input into its content from elected members, I think, could be helpful in the same regard. Claire, did you have something?
No, it's just Councillor Geddes' point about the fact there's a bit of contradiction between your loyalty to as a councillor to the council and the outside body. Is in fact in 317 in the Code of Conduct, Councillor's Code of Conduct, it does say If so, you'll be bound by the rules of conduct of these organisations, and your responsibility for any actions taken by you as a member of such organisation will be to the organisation in question, whilst continuing to observe the rules of this code and carrying out your council duties as well. So there is a bit of a contradiction there.
On that, Alistair?
Yes, indeed, sir. I'm grateful to Claire for pointing out that contradiction. Of course, it'll not be the first time that we've brought to the Standards Commission the existence of such contradictions. I'll go back to the time that Councillors Maitland, Clares and I attended the roadshow in the county buildings. I think it was in 2009, and if memory serves me correctly, and it was the issue of operational issues that was raised on that date, and they promised us faithfully that the next time the code was to be revised, they would take into account the submissions that we'd made. They revised their code and didn't bother, and I would suggest, in fact, that we should be flagging this up as part of the development of a member's role in an outside bodies. Can I crave your indulgence just for a point, sir, if I may? And that's going back to a point that Councillor Maitland made, and you made also. In relation to advisors and observers, the blunt fact of the matter, Chair, is that, inevitably, councillors who are put onto these outside organisations in that capacity will be faced, I would suggest, on a regular basis by requests for information and advice, etc., from other members of the organisations in question. And it will be extremely difficult, if not well nigh impossible, Chair, to adhere to that status rather than to be, as it were, sucked into finishing up as a decision maker with all that that implies. That's the first point. And the second point that you've correctly brought to our attention, sir, in my view, paragraph 2.6, outside bodies, constitutions and officer scrutiny questionnaires, forms can be reviewed on request, viewed on request. I would go further than that, sir, and I would suggest that in the development of these proposals, I would like to see the relevant liaison officer producing on an annual basis, for argument's sake, a certificate for the elected members on the organisation, confirming that it was properly constituted, it was quorted, it was liquid, and it was carrying proper insurance, and that certificate should be provided for the benefit of the relevant elected members on an annual basis, because that's, to me, that simply puts the onus on the elected member. That's not what it should be, in my view. If liaison officers are there to support, they should be providing proper support in the form of certification if need be. Thanks for your
Thank you. Yes, I agree, and I think Councillor Maitland's point was also that if there was a change of officer in the interim, that certificate would be updated accordingly in the name of that officer. Councillor Carruthers.
Thanks, Chairman. I think just going back to Alistair's last point, the last sentence in 3.2, page 11, it says they must also continue to observe the rules of the Council's Code of Conduct while carrying out the duties of the outside body. I actually thought that was quite relevant that it was there, because it protects the Council and any officers. You may well find yourself in a group meeting, you could even for yourselves an administration meeting or a liaison meeting where a particular subject of an outside body where you're at, and there's discussion, and any internal processes that are available to councils in which to influence policy, then it makes it absolutely clear within there that you can't use that influence when you're a member of that outside body, and that's where I felt it was quite applicable, and it protects everybody. So therefore, if a discussion was going on at a high level within those type of meetings, then you could either remove yourself or keep your mouth shut, whatever you wanted to do in regards to that. I've got a few things I'd like to pick up on. 3.9, I've wrote why not and what has gone before. I'll have to reread what I'm meaning by that, which was scheme of delegations to officers. I've underlined the last sentence in particular, where there's a requirement to include delegation to officers responsible for all procurement. Before it's referring it to Rona Lewis as it stands at the moment. What's going on before? Why is that being fixed now, so to speak, or amended? That was one point. 3.8.1, 3 days notice. I felt that was excessive at 3.8.1, because sometimes we get a report and we've got 10 minutes to read it on the day and we can accept it at that. So I thought 3 days before, to allow flexibility in people to substitute, in particular for employment appeals, that should be...
Sorry, can I just... If we concentrate on recommendation 2.1 at this point in time, rather than get confused across the various recommendations, just so that we can logically follow through our decision-making process and rationales.
Right, okay, well, I've got these questions when I read the report a week ago now, nearly. I wrote these down. So.
Well, if you bring the questions up at the relevant point in time regarding the recommendations as we progress through, currently we're on 2.1, and I'm happy to take any questions that are specifically relevant to 2.1.
Well, the point I've already raised, I think I see where Alice is coming from in regards to that, but I think it's appropriate it's left in there because of what I've already outlined.
Okay, thank you. Councillor Hislop.
Chair, it's maybe a minor one, but it was to do with the policy and resources. They allocate the placement an outside body for the Public Health Committee. Most of the work that goes to the Public Health Committee of the NHS is to do with health and well-being, and we're moving the delegation later of that to CCS committee. Should we maybe move the appointment from P&R to CCS as well to keep it in line?
Thank you.
Not very helpful comment through you, Chair, from Councillor Hislop, and certainly historically it would have been policy and resources, given that prior to that we didn't have a community and customer, so a bit of housekeeping there that I'm sure we can look into and take on board. Very helpful, thank you.
Okay, thanks very much. Anything else in 2.1 then? Alistair?
Thanks, Chair. We take the decision to recommend, in fact, that we go down that route, but on the subject to the provisos that we've articulated and raised during the consideration of this specific part of the business.
Thank you. Where do you want to...
Chairman, thank you. You've made a lot of points have been raised there, and I think we've come to the conclusion that there needs to be a distinction between a member's role as, say, a director on an outside body or a trust, as opposed to a member that's appointed in an advisory capacity. So we make that distinction quite clear within the scheme and what the implications of that are. I think we also need to take up again with the Standards Commission, which we have in the past, about the conflict of role between members' loyalty and to an outside organisation versus their role as a member of the council, and the implications it has for declarations of interest or continually having to declare interest. Also the issue about the link officers and the questionnaires, which they are in a SharePoint site, and I don't think we've probably made that very well known to members. I don't know if any members have actually gone onto the site and had a look. It is up to date as far as I'm aware, but we will ensure that members have an input to that. Also suggestion that we have a certificate every year, or a assurance every year annually, that the outside body is properly constituted, it's insured, and we give that assurance to members that it actually still exists, because I know that sometimes members get appointed and never hear from the organisation again. That was an issue that was raised at the last meeting. And also, if the link officers, has changed, we should let you know about that as well. And the point by Councillor Hislop about the Public Health Committee appointment will be taken up with the link officer. Don't think there was anything else that I've missed, Chairman.
Councillor Maitland.
It's a small housekeeping issue, and it wouldn't really have come past us again, but I did notice that formerly the appointment to the Aberdare partnership was one from social work and one from education, and I just wonder if somebody could help me when that changed, because I have to say I looked at this and thought, oh, I appear to be off it now, having been on as a social work member in the past. So, and there isn't social work appointment from here, so I wonder if I could just have some help on that. I don't know if anybody knows the answer to that.
That's quite confusing. There's quite a few appointments that happen from different committees, and it takes some following. Any explanation?
Look into that one. More than happy to take that point on board and come back to the member as well as other members of the committee, Chairman.
Okay, members, happy to go now to recommendation 2.2, consider treatment of trusts and champions as detailed in paras 1.2 above, and note that governance and reporting options for these entities which are not classified as outside bodies will be considered at the next meeting of the subcommittee. Members, any points? Councillor Smith.
I'm just not too sure what 1.2 means. It says members are asked to consider whether they wish trusts and champions to be included with outside bodies, or if not, they will require to be treated separately for governance and reporting. I'm not too sure what that actually means. What do we mean? What will actually happen? I think just as an aside, I think it's important to distinguish between trusts and champions, because obviously you can see a position whereby a trust may, for example, if you look at the Lockerbie and Syracuse Trust, they may approach the council for funding, for example. So a member of that trust would have to declare an interest, not take part, etc. You can see there's a difference between a trust and a champion, which is an internal council position, where I can't conceivably think of a position whereby a member would ever have to declare an interest if they were a champion, because it's purely an internal thing and there's no decision-making powers at all. So I think we have to distinguish between trusts and champions, but I'm not entirely sure what we're kind of being asked to consider, to be honest.
Derek?
Thank you, Chairman. Yeah, it certainly raises a fundamental point. Dealing with the champions first, that's probably the safer ground to start with. I think it's quite clear that we choose to appoint council champions, and they're quite clearly internal. I would acknowledge that when we come to trusts, they certainly get into a number of grey areas. I think historically, a number of these trusts, if not all of these trusts that are named here, have an affiliation, a history with the council. In many cases were initially set up by the council, and to this date my understanding is all of them will still depend upon the council in terms of the financial affairs and financial management. So the suggestion is we're saying that quite clearly, yes, champions are internal, trusts to some extent very clearly external, you could argue, but also because of that historical nature, internal as well. So we're simply saying to members today, for you to decide whether or not you wish them in the outside bodies category, or in fact you want them put in the category of internal, and it's for you to give us a steer on that, Chairman.
Thank you. Councillor Carruthers?
Thanks, Chairman. Just in regards to, if we're looking at this today, is Appendix 2 a guide, or is it factual accuracy, because there is some inaccuracies within there or information not in there? So if we're agreeing that in principle, I'm absolutely fine with that, and I take on the points what Colin's saying. So if it's a principle, absolutely fine to go forward and make a decision, but if not, we need to update the actual information itself.
Yeah, it is in principle, and I think going back also to Colin's earlier question, that in due course, whether it comes before this committee or any other, I think there will be decision making with regard what organisations the council will have that relationship with, and what that relationship format will be in the future. So it's in principle today. Councillor McCarthy.
Yeah, thanks, Chairman. I think it was important we separated the trusts from the champions, because you're at the very first page, page 3, carers champions, that's all 47 members. So if they were treated the same and all 47 declared an interest, the council couldn't function. So I think it's vital that we separate the two functions.
Thank you. Councillor Geddes.
Thanks, Chair. As far as I have no problems with that, but as far as I'm concerned, trusts should be regarded as an outside body, because if you put a member onto a trust, he or she or they, at the end of the day, become subject, well, they're trustees or directors, call it what you will, and at the end of the day, they're subject to the relevant, aspects of company and other company law and other pieces of similar legislation, sir. So I would make a clear distinction, but and say that all trusts, irrespective, and Derek's quite right for the record in my view, but irrespective of their genesis or whatever, they should be regarded as outside bodies going forward.
Thank you. Derek?
No, just welcome the comments from members, and certainly happy to amend the scheme to take on board the comments from members, given that seems to be meeting with consensus. Thank you.
I think it's also the ambition of the council, invariably, if there's a trust set up, to see that trust is sustained in its own right. So there shouldn't necessarily be a presumption of an umbilical continuing between the council and any organisation where it's not necessary or appropriate. Councillor McCarthy?
Yeah, I think maybe even within the trust, the more you look at it, you might have to divide them, because there's some that are outside bodies, quite frankly. The Wigton Rural Development Company, that was set up and we appointed members to it. But if you look at the educational trusts in Wigtonshire, Stuartry and Dumfriesshire, they're set up by the council. I mean, they have outside people on them, but it's not that these things don't invite councillors. The council run them, we appoint councillors, and then we invite interested people to join it. So it's really a part of the council. It's not an outside trust, so it is different from some of the other ones there, the 3 educational trusts.
I think you might find that the way they've been established many moons ago could reflect all different ways of their being birthed. Councillor Gerris?
I think that's very much the point, sir, because in my opinion, with greatest respect, such as the Wigtonshire Educational Trust is not really a trust at all. It may be called a trust, and to that extent, in my view, it's something of a misnomer. Whereas the Wigan Rural Development Enterprise Trust, of which I am the council's representative of the Whithorn Trust, or Macker's Action, these are clearly trusts. And if you're put there as an elected member representing the council in the capacity as a decision maker, you have obligations and duties in terms of the companies and similar legislation. Whereas you don't, I would suggest, have that in relation to such as the Wigtonshire Educational Trust or other educational trusts. And I would suggest, Chair, that is something of a misnomer. And again, that should in fact be looked at and clarified going forward also.
Thank you, Councillor Carruthers.
Thanks, Chairman. I'm glad the debate's going on. I understand a little bit better now, but I'm a wee bit confused in regards to, I thought the decision, with a declaration of interest is one thing, but a conflict is another. And I thought that decision lay with the member. But are we saying here, we're taking that decision away from the member, and we're saying, no, if you're a member that, you will declare an interest, you will leave the room? I mean, I just thought that was up to the member to decide that. That's why I didn't go into great detail earlier.
It very much is ultimately up to the individual member to decide, and we can only ever do that on the merits of the case at any given time. It's not a sweeping statement that can be given as a rule at any one time to cover all eventualities.
I think that's a fair comment, Chair, and that's why I've raised that, because I think it's right what's been saying. A member of a trust is almost like an outside body. Some are slightly set up different from the others, so there would be certainly a declaration of interest, possibly a conflict, but as a champion, like Colin's saying, you're only there to champion that particular subject for a limited amount of time, so therefore I don't see whether there actually be a conflict whatsoever, but maybe still a declarable interest.
Yeah, no, thanks, Chairman. I think the simple point, just simply put across, is that first and foremost, the emphasis at all time on the member is to declare the interest. That's the key principle. It's then for the member to determine, in declaring that interest, the appropriateness of not to stay in for the debate under the consideration of that item. And quite clearly, prior to making that decision, it would be always helpful for any member to seek advice well in advance of the committee when they first identify there being an issue. But the key principle, if they have an interest, declare it. The secondary consideration is whether you stay in the room or not, and we can give you advice on that.
Thank you. Okay, members happy with that? 2.2. Councillor Maitland.
Could I just be clear then? So are we going to do what Councillor McCockery was asking, which is to differentiate between what is a real trust and what isn't a real trust? That will come back to us as part of that recommendation. Is that right? Thank you. Thank you.
I think that's the case in all these instances, not just regarding trusts, but I think as a council we need to assess our relationship with all of these organisations and determine what that ongoing relationship should be. Councillor Carruthers.
I think it's been answered, but so we're looking to, we've considered and we've passed on information, we've discussed it, but we've got a report coming to the next meeting and just to make a decision on how we take that forward.
Yeah, this is the bit that Claire enjoys most, when I ask her to wrap up the debate. Claire?
I'm most adept at it, Chair. You've agreed there's obviously a clear distinction between trusts and champions. There have been different entities. All trusts should be regarded as outside bodies, irrespective of whether or not the council has an admin or financial input to it. It's an issue about actually dividing the trusts up further between those that are strictly trusts in a legal sense and those that have acquired the term trust but effectively aren't legal trusts. And also assess the relationship, I think, with all organisations, outside bodies, organisations, and what that future relationship should be. I think there's just, I've been here 24 years and we've had a scheme for representation in outside bodies, and I think this is the first time we've really looked at it. in huge depth. So it's an opportunity just to make sure that we have the definitions correct in order that members can make informed decisions about whether or not they have to leave the room once declaring an interest. Thank you.
Thank you. And with that declaration from Claire that she's been on a go slow for 23. Okay, if we can go over to recommendation 2.3, agree to recommend to full council the amendment to standing orders in relation to recording of dissent as detailed at para 3.7.3. Councillor Geddes.
Two issues here, sir. No problems whatsoever with what's being suggested. I think it's right and proper that in appropriate circumstances a member should have his, her or their dissent recorded. I would go further and say that not merely the recording of the dissent, Chair, but in appropriate circumstances the reasons, as it were, as you know, for that dissent. Now, I'm not suggesting that the member who asked for their dissent to be recorded gets half a page of justification and reasons, and puts him or her on the equivalent status of the rest of the members of the committee. But I think in certain circumstances, sir, where a decision perhaps is a complex decision or involves various component parts, a member may wish dissent to be recorded in relation to one of these and not in relation to the other aspects of it, the other components of it. And if you don't make that clarification in the minutes, that can create a totally false impression, as it were, as part of a public record, and that this particular member was against the decision per se, when he or she might only have been against a part of the decision. So I think in these circumstances, Chair, I would like to see that amended, not only dissent being recorded, but in certain circumstances, the reasons for why the dissent was recorded. That's the easy bit, I would suggest. The second bit, this does not apply to meetings of the Employment and Appeals Subcommittee in relation to disciplinary and grievance issues. Well, you know my views on this one, Chair. You've had to listen to them. I'm sorry for that. You've had to listen to them on more than one occasion. My view is that the current situation and the current setup is singularly lacking in transparency and, as a consequence, lacking in accountability. I am of the opinion that, where there is a divergence of opinion, for instance, in relation to such an appeals subcommittee, that should be minuted, and the voting should also be minuted, and at the end of the day, that thereupon forms part of the public record.
Thank you. Any other points? Councillor Maitland?
I think I disagree. And just to record, I don't think that's right. I think when you are dealing with something which is a private matter and an individual is involved, I think the decision should be recorded. I think that's all you need to do. I think it's quite wrong, actually, to go into any level of detail. So I'm very happy with the status quo.
Thank you. Councillor Geddes?
Well, there will not be a meeting of minds between Councillor Maitland and I on this issue. That's democracy, after all. But at the end of the day, I can envisage circumstances, and let me be quite honest about it. So you asked recently for members of our group, who are interested in serving in this particular subcommittee, to put their names forward, and that was the reason that I did not, in fact, put my name forward. Because I think in certain circumstances, I or any other member may be fundamentally opposed to a decision which has been arrived at by this subcommittee on a majority of basis. And at the end of the day, I think it's wholly, it's unreasonable and unacceptable to expect a member or members, who are of a totally divergent and different view, as it were, to acquiesce in a situation where their opinion is not in fact minuted and it's not a matter of the public record. I think, as I say, that's singularly lacking in transparency and can leave, in appropriate certain circumstances, the members in question open, as it were, to difficulties.
Thank you. Councillor McCarthy?
Thanks, Chairman. Here what Alice was saying, I've got a slightly different view on that. I mean, bear in mind that it should include the first part of that, 371, because when it comes to appointments are done by secret ballot. If it comes to dismissals, that should be done by secret ballot as well. And I think that's been one of the problems at recent meetings, that we keep taking motions and amendments, and really we shouldn't. You should have a discussion on a a dismissal, but there shouldn't really be somebody, there are three choices you're given, and that's the official jargonese of the appeal is upheld, or the appeal is upheld in part, the appeal is dismissed. And it's either of these things that you move and should then proceed to a vote on that, and that should be done by secret ballot as well. I mean, I think there was good, I think, I hear what Alice is saying, I would like further advice, and I know that the proper officer, Mr Haswell, has given advice on this twice, once in the last 18 months and once some 8 years ago, and I'm not sure whether they took council's advice on this, but I'm aware of 2 occasions where one member wanted their dissent recorded, and that was refused, and the particular member's pretty good at digging his heels in. I think Mr Haswell took advice from council. So I think in this particular one, I don't think there's any point in us trying to argue around this one today. I think maybe perhaps to continue this one and seek some further advice. There is always a question of identifying, and I think that was one of the principal reasons why that advice was given about not recording dissent. Because if you've got 7 folks sitting there and Councillor Smith records his dissent, you know which way the other 6 went. Now, there have been occasions where some of these cases have been quite fraught and difficult, and members have been threatened, etc., etc. But I'm not quite sure where Alec took his advice from. I know he took higher advice, certainly on 2 occasions that I'm aware of. So I think perhaps if we continue this one, that would perhaps be the best way.
Thanks, Tom. Mr Crichton?
Just to confirm, Chairman, I think there's 2 aspects to the debate, and for members to either agree or to clarify. In essence, what we're saying is the dissent would be recorded in terms of 373 for committees other than employment and appeal. So you can either decide today to agree with that, or you can say, no, put the whole thing on hold and we'll await legal advice, particularly in relation to employment law, because I think the debating issue is particularly around the recording of the dissent when it comes to the Employment and Appeals Subcommittee. So it's just to seek clarity from yourself, Chairman, and the members.
Thank you. Councillor Geddes?
Thanks very much, Chair. I mean, as I say, I won't ask for my dissent to be recorded for the record, but I have no problems with agreeing to Councillor McCaughre's suggestion. I think we should get further advice on it, and if in fact it can be demonstrated that on the back, particularly of employment law, that there are good and onerous causes, for want of a better term, I'll live with that. But as I say, I think we should look at it, and I also would hope so that members would accept in appropriate circumstances not just the recording of dissent, but the specification as to why the dissent is being recorded.
Councillor McCarthy?
I mean, I think I hear what Alice is saying, but it's a double-edged sword, because it's all very well being allowed to record your dissent in dismissal cases, if you like. But I'll turn it around another way. What about appointments? Suppose it comes to the appointment of a new chief executive, and 47 members present, and we take a vote on it, and I say, I think you're all wrong, I want my dissent recorded. Now, I'm going to have a very difficult relationship for the next few years with that particular chief executive who happens to check the minutes. So I think a wee bit, I think we have to think about it. So it's one thing with a dismissal, because obviously you're recording your dissent because somebody's been dismissed, they're out with the employee of the authority. But if you then want to record your dissent on an appointment, you as a councillor are leaving yourself wide open to that official sort of saying, oh, well, if that's what he thinks, we sod him. Not officials would say that, of course, but I might.
Is it on this point, Ivor?
It was exactly the same, but I was looking at it from the fact that if there's 2 people up for appointment and one went through as moved an amendment, and say the internal officer never got the appointment, you could curry favour with that internal officer by asking for your dissent to be recorded. Now, I always thought that would, rather than just disciplinary and grievance, maybe also in employment.
Thank you. Councillor Maitland?
Yes, I mean, I think members are edging towards that, but I think what we were being asked to decide is whether or not, out with employment or grievance and appeals, were we prepared to agree with what is proposed here about recording dissent. Councillor Geddes was giving a reason, and while that's quite alluring, if it's, say, for argument's sake, because you haven't been able to agree with the whole series of the motion or amendment, whatever it is, nevertheless, you would find yourself, so she losing the thread of what she's actually trying to say. No, you would find yourself normally able to say, but Chairman, could we please take that part of the agreement first? You could actually procedurally carve out one part of the decision and then disagree with the second part. You could ask the Chairman to do that. And I think it would be very unreasonable, Chairman, who wasn't prepared to carve that bit out and then not make the second part clear. So I mean, I would have thought we could get round that particular issue by procedural matters in the chamber.
On that point, Alistair?
Very much so, Leader. Chair, with your leave. That may be the case in certain circumstances. It may not always be the case, and I think in appropriate circumstances there should be there should be the discretion afforded to the chair and to the committee of the day, where they feel that it's appropriate, as it were, to incorporate the elected member's reason for his or her dissent being recorded. I don't think that's unreasonable. It improves and enhances transparency, and through that enhances, at the end of the day, accountability, in my view. So that's that. As I say, that's what I'm seeking in relation to that, and I'm also seeking in relation to the issue of the Employment and Appeals Subcommittee further consideration being given to that, as I've already indicated.
Thank you, Councillor Carruthers.
Chairman, as far as 3.73 is concerned, quite happy with the new standing order. I think employment appeals should stay the same in regards to recording dissent. I don't think we should be able to, but really intrigued by Councillor McCaughtrey. I don't know how that would stand with standing orders, but I think really intrigued. I think it's a good idea that it should be a debate, full discussion in regards to whatever the subject is, but then a secret ballot thereafter, and whatever the outcome of that is, it is. I think that's a really good idea. I've never heard that being proposed before, rather than being a motion and amendments.
That's what it says in standing orders.
Is it?
Just we haven't been doing it.
All right, okay.
Just to clarify, there's no need in an appointment of officers to have motions and amendments, because unless there's a unanimous decision to appoint one candidate over the rest, it has to proceed to ballot, and then candidates are eliminated through a process in Standing Order 10.3. So.
Thank you. Councillor Smith.
On the issue of dissent, you can only record dissent if you've actually put forward an amendment, but haven't had a seconder. So the way to record it is to record the amendment and just simply say there was no seconder. I mean, that's the reasons why you're having your dissent, because you didn't get a seconder for your amendment. Because if you get in a situation where you're going to have a narrative as to your reasons, then frankly, I want a narrative as to why my motion went through and why I supported it. So I think just simply saying if you put forward an amendment, you record the amendment, but you say that there was no seconder, and if the person requests their dissent to be noted, then you simply record the amendment and say there was no seconder and Councillor so-and-so's requested their dissent be recorded, and that's the best way of doing it, because we don't minute the debate and the reasons. All we minute is the decisions and the amendments, etc.
Thank you. Councillor Geddes.
I'd be well satisfied with that, sir. At the end of the day, as I say, as long as it, in appropriate circumstances, it lets the individual concerned see, well, you know what I'm saying. I'm well satisfied with that.
Councillor McCaughtrey.
Yeah. Just happy to second Councillor Smith. I think that's the best way forward. I mean, if you record that Councillor Collins moved such and such a motion sent by Councillor Hislop, Councillor Smith moved the amendment, found no seconder, Councillor Smith then asked for his dissent to be recorded. That's it. End of. So it's really a minute writing style you need, and a slight amendment to standing orders.
Okay, Derek.
Thank you, Chairman. More than happy to proceed on that basis, the essence of that being where there is not a seconder for an amendment, that the member has the right to have their dissent recorded, and will come up with the appropriate wording that covers that. If committee are comfortable, Chairman, through you, I would be suggesting in the first instance that we give further consideration and look at the legal position in relation to employment law with regard to its application by the Employment and Appeals Subcommittee, if you're happy to allow us to do that.
Yep. Members content of that? Okay, we move on to recommendation 2.4. Note Council's advice regarding Standing Order 13.1, agree that the status quo prevails as detailed at para 376. Members, any questions? Councillor Carruthers?
Just I would like to have seen the Council's advice. It's not there explicitly.
Council, it was more Council's, not advice as such, because he said it was not a matter of law, therefore it was purely just advice, not an opinion as such. So it was really for the Council to determine its own standing orders. So it was advice, verbal advice, rather than Council's opinion, which would be written down.
Councillor Geddes?
I commend Claire for her diplomacy, sir. I thought she was going to say that it's an operational matter, Councillor Crothers, in which you have no locus. But
Alec might have said
irrespective, my question is quite simple and succinct, sir, in relation to paragraph 3.76. Why?
Derek,
Yeah.
please.
Thank you, Chairman. Yes, Mr Haswell, certainly in preparing for today's meeting, I had the occasion to discuss this report with him, and he certainly highlighted to me that from his perspective as the Council's monitoring officer, the scheme was fairly clear, fairly robust, that all committees have a number of delegations, and therefore there is ample mechanisms for members to bring forward business to committees. Where that's not on the programme, as we know, Standing Order 17 provides a member with the opportunity to also request that an item of business be brought forward to the relevant committee. And therefore, the status quo seems to be working well, is the view of the monitoring officer. And on that basis, that the arrangements suffice, and there is clearly opportunities for both members and officers to ensure that all business comes before the appropriate committee of the Council, and therefore would wish to continue with that arrangement. Thank you, Chairman.
Grateful for the response, sir. Don't necessarily agree with it, but I'm grateful for the clarity and succinctness of it.
Why not?
I'll explain if you want. You've already had to put up with it today.
Any other questions? Okay, Claire's in. You'd like to add at 2.4?
No, I think it's all been put very nicely.
Can I just ask one small point, then, Chair?
Sorry?
Can I just ask one small point in regards to that?
Yeah.
It's only in regards to, say a motion was put forward and it wasn't accepted. Does the member or members, whoever it may be, automatically say, listen, this is for a service committee or corporate committee, then you should put it to them? Is that an automatic thing that happens? I'm assuming that it is. No. Or not?
I think it's up to the member to seek advice from officers as to what the best way forward would be in that particular instance for that member.
If I was to put a motion forward to listen, that's not acceptable at full council, you thought it would have been something saying, listen, it shouldn't have got full council, it should go to EEI, it should go to Policy and Resources, Community Customer Services, wherever. That's all I'm asking. Is that the case? Because I think that's when I read this, that's what I feel the point that's being made.
I think the issue is when it's a notice of motion that's on a delegated matter, there's a number of notices of motion that go to the Council that are not specifically delegated to a committee, therefore they can be discussed at full Council, but where it's an item that's delegated to a service or corporate committee, then the removal of delegation has to be agreed by the full council. In this circumstances, it hasn't been, so the member in question wished that matter then to go back to the service committee, like a reversal of delegation. But the full council back in November agreed to keep Standing Order 17 within Standing Order 15, i.e. it does not apply to committees.
Councillor Hislop.
Possibly one of my famous Daft Laddie questions. Who is the proper officer? Is that the Director of Chief Executive Services, or is it the Director of the appropriate committee?
When I refer to the proper officer, it's always Alec as Director of Chief Executive Service for committees of the Council. A number of proper officers, but Alec in terms of Local Government Scotland Act and the Access to Information Act in terms of committees and subcommittees of the Council.
Councillor McCarthy.
Yeah, I'd make the point, there's actually, the way we operate now, there's actually protection there for the individual member. Now, we do have one member who's not a member of any political group. He has got the right at the moment to go to the proper officer and request something goes to a committee he is not on. If you take that right away by having to have a motion to a committee, that then requires a seconder, and therefore you're taking the onus away from the individual and handing over to political grouping or body or whatever. And therefore, I think there's safety there for the individual member in the way we operate at the moment. If you change that, you actually give lesser powers to elected members than they currently have.
Okay, thank you. Move on now to recommendation 2.5. Agree to recommend to full council the amendments to the scheme of administration and delegation to committees as detailed at paras 3.8.1 and 3.8.2. Members, any questions? Councillor Carruthers.
Chairman, just back to one of the points I made earlier. I think the 3 days notice, I don't think we really need that. Maybe it should be reduced or taken away completely at 3.8.1 and 3.8.2. Does that mean that we can do away with the Welfare Reform Committee? Because health and wellbeing then goes to community customer services.
I think on the first one, the 3 days would be a bare minimum that would be expected by members, because in some instances the amount of papers that you might find yourself having to wade through with the 1 day to go or 2 days to go would be unreasonable as an expectation. So 3 days is seen as being the minimum time of notice given to a member who would substitute on a committee. I think that's perfectly reasonable, and I wouldn't like to think of any member being dumped on with a pile of papers with less than 3 days to examine the case and make a reasonable fist of decision making in that instance. Mr. Crichton.
Thank you, Chairman. Just to echo your own comments, that we would certainly be recommending a minimum of 3 days for the very reasons you've set out in your comments. In relation to paragraph 382, clearly it's for members to determine the composition of committees, but certainly at this time the Welfare Reform Committee has been given enhanced powers and has a very clear remit in terms of particularly tackling the issues that arise from welfare reform, and that's quite distinct from health and wellbeing, which is more about the preventative health and lifestyle, quite different from the remit of the Welfare Reform Subcommittee.
Thank you. Councillor McCarthy.
Yeah, just on the employment appeals, I mean, if you recall, they used to have an 11-member employment appeals committee with 11 substitutes, and it was usually the parties themselves, if somebody couldn't make it, another member of that group would substitute and usually exchange papers. What you've got now is it's done by the centre, the per many 7 from 19. And obviously, I've done it myself, if somebody's had to call off at short notice, and particularly in the dismissals, I mean, you do need 2 or 3 days notice. You can't just do it in the morning. You're talking about quite thick reports that require a bit of reading. So I think it's a protection there for the person involved as well, never mind the elected members. It's a protection there for the individual whose case you're going to hear.
Okay, thank you. Any members, any further questions? Happy at 2.5? No. Anything you want to clarify, Claire?
Just to clarify, Chairman, that we refer to replacement members rather than substitute members, because there's no substitution permitted. So it's just a technicality there.
Thank you. On to 2.6, note the amendments for the scheme of delegation to officers as detailed at para 3.9, and a revised scheme will be considered at the next meeting of the subcommittee. Is there any other questions? Councillor Carruthers?
Same one as earlier, Chair, in regards to pretty much why not and what's gone before in regards to 3.9. We're at the place where we're making this amendment and change. What was it previously and why? That's pretty much it.
Councillor, sorry, Claire.
I was just to say the scheme wasn't laid out in the fashion that it was obvious to members which were statutory and which were non-statutory delegations. So it was just a scheme that was very up to date and was very clear to members where there was a statutory delegation, say trade and standards, environmental health, as opposed to a non-statutory delegation. So that we separated these out.
So just update and bring it up to speed.
Thank you. Councillor Hislop?
Chair, it's just for the fact that the Scrutiny and Performance Committee are doing a bit of work on the procurement rules and the standing orders. I take it this will not be set in stone. I don't think we would have any problem with this, but we might want to look at further delegations if there was to be a bigger procurement team or something like that that we could look at.
Thank you. Yep. Councillor Maitland?
Yeah, I'm sorry, I'm just obviously missed it. But in the answer to Councillor Carruthers' reason, I was looking at the sentence which said, "In the meantime, there is a requirement," and I don't really understand why that suddenly changed. I mean, I think that's what we're getting at. The delegation will be added to the scheme as an amendment authorised by the Director of Chief Executive Service, and I don't just completely understand what's going on. Why is this suddenly in there?
Claire?
Basically, Councillor Maitland, because it was missed and it required to be a delegation to Senior Manager, Legal and Regulatory as the procurement manager. It wasn't in the scheme and we were asked by the auditors to make sure it was in the scheme. So it was just to alert you to this fact. It's already in there, but just to let you know that we've put this in advance of any revised scheme coming before you at a future meeting.
One all. Okay. Councillor Geddes?
When is the next scheduled meeting of the subcommittee, sir?
Chairman, I don't have dates fixed, but I'll discuss this with the Central Diary Keeper and try to get them scheduled in as soon as possible.
Thank you. Ivor?
Similar vein, when do we hope to have this report to full council so that we can put them into the actual schemes of delegation and administration?
I'm not entirely sure when the next full council is. I should know, but I'll make sure there's a priority piece of work for the next full council.
Councillor Carruthers?
Thanks, Chairman. Just in regards to, it's a question I picked up, which I haven't picked up through as we went through the actual meeting in regards to Appendix 2, 3.4. It's a simple question. It says members should be aware that when they take on an advisory observational role. Could you just give me an example where we would advise the observers, please, and this in regards to outside bodies?
Sorry, could you just repeat the question?
I'll be absolutely specific. 3.4, what does that first sentence mean? Page 11. When does a member become an advisor or an observer to an outside body? In particular, the advisor's role. I'm just trying to think of a place where I've been an advisor or other members actually been an advisor. Just try to put that into context in my own mind.
Very clearly that will emerge when we now do the next stage of the work, given the principles being agreed, but I heard comment, I think it was Councillor Maitland, Kirkcudbright swimming pool user group, for example, there may well be the same in Annan, Councillor Carruthers, so that type of body could well be somebody that you quite clearly just provide a link, advisor role more than anything else, but that will come out when we now amend the scheme and categorise them on the two premises that have been agreed by the members this afternoon.
Councillor Hislop.
Just, maybe I should ask at the right time as well. Who's liable if you give wrong advice?
The individual councillor concerned, and it starts from there and cascades down.
You would still be liable if you were given wrong advice as an observer.
Okay, members, no other questions? I've no other business. Thanks very much for your attendance today. Thank you.